Welcome to the video lecture on East Asian States Leadership International Law. This section will talk about national practices of the couple of states in East Asia. The first, we are going to talk about issues of the Korea. So this lecture is about national practice of Korea for the interpretation and application of international law. Due to the historical and geopolitical reasons, South Korea faces inherent limitations in its reliance on interpretation and application of international law. The intricate entanglement of factors such as the complex relations with Japan, rooted in colonization of the Korean Peninsula, the enduring dynamics of the inter-Korean and U.S.-Korea relations in post-Korean War, and economic interdependence and the evolving significance of the Sino-Korea relations reflect the multifaceted nature of South Korea's international landscape. The adept management of these highly dynamic bilateral relationships is directly linked to the nation's survival. Moreover, given South Korea's position as a member of the international community, as well as the United Nations, a clear interpretation and application of international law in navigating multilateral relations is very vital. The recent security cooperation among South Korea, the United States, and Japan in response to North Korean nuclear threat and participation in the global supply chain vis-à-vis China and Russia both function as significant variables. Of the East Asian countries, namely North Korea, Japan, China, and Russia, and South Korea's distinction as the sole country that actually undergoes periodic regime changes through democratic processes, this serves as a valuable asset to the country. It is also serves as a source of resilience for South Korea in the face of the tumultuous global politics between major powers. To effectively manage this national asset, particularly as a nation that is primarily engaged in bilateral diplomacy over multilateral diplomacy, South Korea must possess a comprehensive understanding of the current issues and a clear awareness of the disparities between domestic and international law and politics. Then, what criteria and operations and orientations does South Korea employ in interpreting and applying international law in the face of complex national issues? Have policy alternatives based on such interpretations been appropriately executed? Going further, can South Korea lead in shaping international norms? These questions should be answered very clearly. The Korea's fundamental perception of the Korea-Japan relations, including 1965 Treaty on Basic Relations between Japan and Korea, is the legality of the Japanese colonial period and invalidity of the series of treaties that justified the decolonization. This is the basic issues we have to start to talk about, respond to national practice Korea for the interpretation and application of the international law. This can be observed from the decisions from the Constitutional Court and Supreme Court regarding comport women and forced labor issues during the Japanese colonial period, as well as the continued conflict between Korea and Japan over the sovereignty of Dokdo, which is recognized as one of the first territories taken from Korea in Japan's quest to annex the entirety of the Korean Peninsula. With the positive approach being the prevailing method of interpretation for contemporary international law, there is a significant gap between international legal assessments and the historical judgment of the legality or invalidity of treaties conducted during Japan's colonization of Japan. The September 19, this comprehensive military agreement, supplementary the agreement to the September Pyongyang Joint Declaration, adopted by then President Moon Jae-in and North Korean leader Kim Jong-un at Pyongyang Summit on September 19, 2018, was anticipated became a point of contention for Yoon Suk-yeol administration due to the fundamental differences in perceptions regarding inter-Korea relations. As expected, it has recently become a subject of controversy, particularly regarding the core issue within the Comprehensive Military Agreement, which concerns the asymmetry of the designated maritime cessation of hostile act zone. This is a fundamental link to the diverging perception of the northern limit line in the West Sea and the undetermined maritime boundaries in the 5 West Sea islands between North and South Korea. This is another instance where changes in the administration have influenced the interpretation and application of international law regarding the need for stable management of the marine order on the Korean Peninsula. International law provides a legal foundation for diplomatic relations in international affairs, while diplomacy in accordance with the international law is ideal. The pursuit of national interest in diplomatic endeavors may not always align with international legal principles. However, in diplomacy, even major powers tend to invoke or present international legal agreements despite their limited persuasiveness, rather than outright denying or challenging international law. Therefore, for foreign relations decisions are not based on diplomatic policies of the regime, the post-regime change in domestic political judgment must be limited since regimes are always subject to change. Moreover, such judgment should be especially avoid employing the domestic legal standard recklessly. In other words, any attempt to alter pre-existing international relations already shaped by the international law after regime change require careful consideration. In a different context, the recent remarks by the Nobel laureate during his visit to South Korea, highlighting the divergent cycles between scientific developments and electoral processes, underscore the noteworthy point. Given the historically Eurocentric nature of traditional international law and its use as a tool for unfair dominion over non-European regions, it is challenging to transform the traditional international law into a universal law that constitutes the genuine interest and justice of all humanity. From this perspective, it is imperative for Korean community of international law to emphasize the need to interpret and apply international norms in a post-colonial era that genuinely reflects the interests of all to resolve the current issues between Korea and Japan. This involves understanding the historical facts and untangling the intricacies of the victimization that occurred during Japan's annexation of Korea. In a sense, this can be understood as the application and understanding of international law from a Korean perspective. However, the issue is whether this application and understanding of international law from a Korean perspective will be adopted as international norms. The scholars from the third world countries, including newly independent countries like India, have critiqued the legal principles set forth by the contemporary international legal institutions that uncritically permit past imperialistic states indiscriminate territorial expansion, particularly in the context of the territorial disputes. Such critics, as seen through positive and functionalist judgments, have now received much sympathy from within international academy. Moreover, there is currently no compelling alternative discourse being put forth. Therefore, overcoming the dualities of acknowledging the need to advocate for the legitimacy of the applying international law from a Korean perspective, and recognizing the inevitable limitations that arise in the process is expected to serve as an alternative in addressing Korea's historical issues. However, concerns remain regarding the potential lack of the success in this endeavor. Thank you very much for this, for your attention for this lecture. Thank you.